Now, I may approve of PETA in principle, but not necessarily in action, although in as much as I disagree with them in action, every now and again, they are nonetheless right. Viva Frei, Montreal litigator turned YouTuber, and this is Winnie the Westie. Now, I am not in my office. I don't have my office right now. I am at my parents' cottage. We have not had running water for the last 24 hours because the pipes were frozen. I actually took a bath last night with a rag and a pot of melted snow. I am at home with my youngest, whom I plopped in front of the television so I could put this vlog out. Robert Barnes has been sending me my homework, so I've read through a bunch of decisions, a bunch of lawsuits, and I came across one which I figured I would do a quick vlog on because it involves PETA, it's kind of funny, and even if you don't like PETA, you have to agree with the decision. In the United States District Court for the District of Maryland, People for the Ethical Treatment of Animals, Inc., Plaintiff versus Shore Transit et al. Defendants. Memorandum. Plaintiff, People for the Ethical Treatment of Animals, Inc., PETA, brings suit for declaratory and injunctive relief against defendants Shore Transit, Brad Belichico in his official capacity as Director of Shore Transit, and the Tri-County Council of the Lower Eastern Shore of Maryland. PETA brings suit under 42 U.S.C. Section 1983, alleging that defendants violated and continue to violate its First and 14th Amendment rights by denying it permission to display two advertisements on Shore Transit's advertising space. Pending before this court is defendant's motion to dismiss. The motion is fully briefed and no hearing is required. For the reasons set forth below, the motion to dismiss will be denied. I suspect that everybody out there already knows a bit about PETA and knows that they have something of a bad reputation, not because they are people for the ethical treatment of animals. Who could possibly have a problem with that? It's just that sometimes they make some rather offensive, callous statements as relates to humans. Sometimes they make some offensive and callous comparisons to historical events as relates to the treatment of animals. They run some edgy advertising, to say the least. Others might call it shocking and appalling, and in this particular case, they wanted to run two ads, I suspect on a bus, and they were rejected, but the reasons for which the ad was rejected, you can understand why PETA filed suit. On May 12, 2020, PETA submitted two proposed advertisements to Shore Transit through Vector. Both included the text, quote, "No one needs to kill to eat. Close the slaughterhouses, save the workers, their families, and the animals," end quote. One had the word, quote, "kill," end quote, superimposed on a bloody cleaver. The other includes an image of a child holding a chicken. Mark Sheely, Vector's regional manager, forwarded the proposed advertisements to Belichico, asking if Vector had permission to sell PETA exterior bus advertisement space to display them. On May 15, 2020, Sheila forwarded PETA Belichico's response. Quote, "After considerable consideration, we will decline the PETA ads. We find them too offensive for our market and political in nature," end quote. PETA was obviously unhappy with the decision, and they made something of a request for documents under Maryland law, and they basically got documents confirming that Shore Transit rejected the ad because it was political in nature. They didn't like the ad, they found it offensive, yada yada yada, but at the same time, they also refused to run ads for some marijuana cannabis company. But the real issue and the terminology on which this judgment ultimately dismissed the motion to dismiss relates to the terms in the actual Shore Transit contract itself. Under the contract, Shore Transit, quote, "reserves the right to reject any advertising that it determines to be controversial, offensive, objectionable, or in poor taste," end quote, and, quote, "reserves the right to remove any offensive advertising at any time," end quote. These terms are not further defined in the contract or in other documentation. So Shore Transit et al. File a motion to dismiss on the basis that their contract allows for them to refuse to run any advertising that they deem to be controversial, offensive, etc., whatever, and that therefore PETA has no cause of action, and that the action should therefore be dismissed, and the judge says, no, because this broad, vague terminology does not provide a framework within which PETA can operate. We don't really need to get into the thick of the details, but the court ultimately concludes that the advertising space is itself a non-public forum, and that therefore these considerations apply. As noted above, the court assumes for the purposes of resolving the instant motion that Shore Transit's advertising space is a non-public forum where a more permissive standard applies to government restrictions on speech. Any regulation on speech in a non-public forum must be, quote, "reasonable in light of the purpose served by the forum and viewpoint neutral," end quote. The court finds that, as alleged, defendant's prohibition on advertisements that it deems to be political, controversial, offensive, objectionable, or in poor taste does not satisfy even this, quote, "forgiving test," end quote. Basically, the court deems the terminology to be too broad and ambiguous to be workable, that any party does not know what they have to do in order to be compliant, and that therefore it does not satisfy the requirements in order to restrict speech if you are a government entity. And not just that, the court ultimately comes to the conclusion in dismissing this motion to dismiss that the discrimination is itself not even viewpoint neutral. As alleged, the advertising prohibitions are not only unreasonable, they are also viewpoint discriminatory. Quote, "The government violates the First Amendment when it denies access to a speaker solely to suppress the point of view he is predisposes on an otherwise includable subject, end quote. As the Fourth Circuit has explained in both public and non-public forums, quote, a policy that does not provide sufficient criteria to prevent viewpoint discrimination generally will not survive constitutional scrutiny, end quote. Further, quote, viewpoint neutrality requires not just that a government refrain from explicit viewpoint discrimination, but also that it provide adequate safeguards to protect against the improper exclusion of viewpoints, end quote. Now, this judgment does not necessarily sanction or otherwise approve of the ad that PETA wanted to run in the first place. It just basically says that the terms that Shore Transit are using in order to decide whether or not to approve an ad are basically arbitrary and do in fact discriminate, but that I suspect if Shore Transit ever came up with more specific terminology, more objective criteria, like for example, we will not run ads with blood in it, I don't think they would have had this problem in the first place. The issue is that the criteria are so nebulous, so vague, that PETA does not have a reasonable workaround, that the Shore Transit can basically use it to discriminate against people based on viewpoint. And on the 14th Amendment, the judge also has this to say. PETA's 14th Amendment claim will also survive dismissal because PETA has sufficiently alleged that defendants' prohibitions are vague. Quote, a statute can be impermissibly vague for either of two independent reasons. First, if it fails to provide people of ordinary intelligence a reasonable opportunity to understand what conduct it prohibits. Second, if it authorizes or even encourages arbitrary and discriminatory enforcement, end quote. As discussed above, PETA has sufficiently alleged that defendants' prohibition failed to provide clear or workable standards or to protect against arbitrary enforcement. So that is it. You don't have to like or approve of PETA in order to recognize that this decision is well-founded in law, and every now and again, even a squirrel finds the nut. You know what I mean. But that's the decision to be discussed this evening with Robert Barnes, among other amazing topics. If you like my videos, you know what to do. Like, share, subscribe, hit the notification bell, and drop a comment in the comment section below because it feeds the algorithm. Poop again! If you want to support the channel, all of the support links are in the pinned comment. We've got a bunch of merch, including a new design that I just put out yesterday. If you are so interested, Robert Barnes and I do weekly live streams every Sunday. We do weekly streams with a guest every Wednesday called The Sidebar. If you want to find us and support us on Locals, where supporters get tons of exclusive content, you can find us at
VivaBarnesLaw.locals.com.
All of my content is also on Rumble, which has recently merged with Locals, so they have a nifty little widget on the Rumble platform where you can find our Locals community if you are so inclined. But more important than anything, take care of yourselves, check in on friends and family, make sure everyone around you is doing well, and now you know your vlog. Peace out. Booyah! I didn't do the peace sign.